ask the question that you have so that we are able to address it. Okay. Tuko na swali. When you're gonna swali, we can start with you as we narrow down. No question, we are fine. All right. It looks like we are all good on that front. So let us start. So in the last class, guys, we talked about intestacy, and that is the rules of intestacy, the rules governing intestacy. We spoke about all the rules governing intestacy from section 35 all the way to section 41. Okay. So today I want us to move away from there and do a little bit of deep diving into some of the issues that I want us to discuss. The first one is a question of jurisdiction. The first one is a question of jurisdiction in terms of probate. What is the jurisdiction of courts in probate matters? The second thing is the question of intermeddling. And the third thing is the question of contentious and non-contentious probate. So those are the three things that I have lined up today so that we can go through them and understand. But also, I'm just reminding you that I've given assignments on certain things within the course of our discussion. This is our 6th class. I've given several assignments that I want you guys to do. I am not requesting you, I'm asking you guys to do those assignments so that we are on the same page in as far as this thing is concerned. Like I've said, this unit is very easy, but if you play with it, you will not like it. Okay? It is very, very easy, but if you play with it, you will not like it. So please do the assignment, do the reading, and everything else is going to be fine. Very, very fine. Okay? So just please. Now, let us start with the question of jurisdiction. Let us start with the question of jurisdiction and just give me 1 second as I bring the act up. I'm trying to bring the act up in 1 second. Kenya database. So the question of jurisdiction. There we go. All right. All right. Can you see my screen?
On my side, not yet.
Not yet.
All right.
No.
Let me try and bring it up again. Right there. Can you see it now?
Yeah, you can see it.
All right. Very well. Very well, very well. So I want us to go straight and discuss the question of jurisdiction. There's nothing much about jurisdiction. There's nothing much about jurisdiction that you need to understand that much. You just need to understand in terms of filing of grants, which code do you approach, and in terms of, so that's what I'm saying. So if you look at section 48, if you look at section 48 and 47, they talk about jurisdiction, and also section 49 that brings a question of territorial or geographical jurisdiction. So section 47 says that the High Court shall have jurisdiction to entertain any application and determine any dispute under this Act, and to pronounce such decrees and make such orders therein as may be expedient, provided that the High Court may, for purposes of this section, be represented by a resident magistrate appointed by the Chief Justice. Okay, so you know this part that in most instances, powers of the High Court can also be exercised by the resident magistrate. The resident magistrate, or the RM, is normally the defunct registrar of the High Court, and therefore certain powers of the court in probate, that is the High Court, can be exercised by the registrar. I mean, that is the RM, the resident magistrate. Are we together? So that is the overall jurisdiction in probate matters is usually with the High Court. It is usually with the High Court, but the High Court can allocate that power, or can delegate that power to a resident magistrate. And sometimes, if you've been in practice, you've realized that certain matters in probate are being filed in the magistrate court. The reason why they're being filed in the magistrate court is because the High Court has the power to allocate the jurisdiction under Section 47 to a person sitting in the office of the resident magistrate. Okay, and then 48 now brings the jurisdiction of magistrate courts, which is clear, which is purely on the context of the pecuniary value of the estate. It says that notwithstanding any other provisions of written law which limits jurisdiction, but subject to the provisions of Section 49, which is on the question of territorial jurisdiction, a magistrate shall have jurisdiction to entertain any application and to determine any dispute under this Act, and to pronounce such decrees and make such orders therein as may be expedient in respect of any estate, the gross value of which does not exceed the pecuniary limit prescribed under Section 7 of the Magistrates Courts Act, that is Cap 10 laws of Kenya. So what is the essence of that? We are saying now, even though the overall jurisdiction is given to the High Court, the magistrates shall also have jurisdiction to entertain any question of probate, provided that the value of the estate, the pecuniary value of the estate, is not more than 20 million. Remember that as per Section 7 of the Magistrate Courts Act, the jurisdiction of magistrate courts is limited to the pecuniary value of up to 20 million. So if the value of the estate, if the net estate or the net value of the estate, actually the gross value of the estate is more than 20 million, then we are going to file the matter in the High Court. And then if it is less than 20 million, we are going to file it under the magistrate court. Okay, so most instances you'll find some people that want to avoid the jurisdiction of magistrate courts and they want to go straight to the High Court. They will inflate the value of the estate. They will say the estate is valued at 21 million, and that automatically takes them to the High Court. Okay, so that is what we are calling the jurisdiction of the High Court and the jurisdiction of the lower court, that is the magistrate court. What have I said in short? The High Court has the overall power, of course, to entertain any application regarding the provisions of the Law of Succession Act and its subsidiary legislation, as well as entertain any matter that is related to that specific act or specific legislation. So any matter regarding probate, whether it is above 20 million or below 20 million, can be entertained by the High Court. However, the High Court can also delegate that power to a resident magistrate. So a resident magistrate is normally considered as the secretary of the judge, informally secretary of the judge. So that resident magistrate can exercise the powers of a judge in probate matters. Okay, they can propound a will, they can approve applications, they can give orders, they can, all those things, because they're being apportioned that power by the judge of the High Court. That is the first thing that I've said. The second thing I've said is that when it comes to the jurisdiction of magistrate courts, there are two aspects. The first aspect is the pecuniary value or the pecuniary limits. We are saying that a magistrate court can only handle up to a maximum of 20 million. So anything that's above 20 million, of course, the gross value of the estate, if it is above 20 million, then of course, you file it in the High Court. If it is below 20 million, then you can file it in the magistrate court. Are we together? So that is the question of jurisdiction in as far as the High Court and the Magistrate Court is concerned. Now, when you look at Section 49, it talks about now the territorial jurisdiction of magistrates, whereby if a magistrate is in Nakuru, they are supposed to handle Nakuru matters, for instance. Okay, it says that the magistrate courts are within whose jurisdiction, within whose area a deceased person had his last known place of residence shall, if the gross value of the estate of the deceased does not exceed the pecuniary limits set out in Section 7.1 of Cap 10, that magistrate will have, in respect of that estate, the jurisdiction conferred by Section 48. Okay, provided that the magistrate may, with the consent of the direction of the judge, transfer the administration of that estate to any other magistrate court where it appears that the greater part of the estate is situated within the area of that other magistrate, or that there is other good reason for that transfer. So essentially what we're saying is that a magistrate will have jurisdiction if that person that died had his last known place of residence within his jurisdiction. So if it's the magistrate court in Kiambu, for instance, then we are saying the person must have died in Kiambu, or must have died a resident of Kiambu, or had a larger chunk of his estate in Kiambu. So in that essence, we also have the question of transfer of cases from one magistrate court to the other. If it is believed that, yes, I am the one with jurisdiction, but he had 80% of his estate in another jurisdiction, we can transfer that matter to that other court, of course, with the consent of the High Court of that jurisdiction. Are we together? So it's nothing much about jurisdiction. You just need to understand the jurisdiction of the High Court, which is the overall thing. You need to understand the jurisdiction of the magistrate courts, which is limited up to 20 million. And then you need to understand the question to do with the territorial jurisdiction, which only gives the magistrate courts the jurisdiction to entertain applications or probate issues within their local area. That is jurisdiction. Guys, that is jurisdiction. Are we guys together?
We are together.
All right. Any question? All right, that's fine. That's okay. Now that is jurisdiction. There's nothing much about jurisdiction unless you are being told to advise or prepare an opinion regarding jurisdiction or such and such and such. So that is all about jurisdiction. Now let us go and talk about the second thing that I've given us. That is the question of intermeddling. Intermeddling. What is intermeddling with the estate of the deceased person? Intermeddling with the estate of deceased person. What is the act of intermeddling? What is intermeddling? Now, some of you people like intermeddling with the estate of the deceased person. You like intermeddling with the estate of the deceased person. Okay. And I'm speaking directly to the wife inheritors from Luo Nyanza in Western Kenya. I don't know what's wrong with those two communities. Of all the things you can inherit in the world, you want to inherit a wife, Luo Nyanza and Waluya. Nafaa tumweke tu kwa room moja, mpigwe viboko vibaya sana. Don't intermeddle with the estate of the deceased person, okay? Including the wife of the deceased person. One day, while you're busy inheriting, you shall see fire. The deceased person will come back at night when you're sleeping in his bed, and you will know. So, what is intermeddling? What is intermeddling with the estate of the deceased person? What is intermeddling with the estate of the deceased person? Intermeddling is very simple, guys. Intermeddling, an act of intermeddling is very simple, and it comes from a very simple rule. What is the rule? The rule is, do not touch the estate of the deceased person or anything that forms the estate of the deceased person without authority. do not touch anything that forms part of the estate of the deceased person without authority. Okay? So anytime somebody is handling the estate of the deceased person without authority, that is intermeddling. That is intermeddling. Are you guys together? That is intermeddling. Now, guys, what is this authority? What is this authority that we're talking about? What makes part of the authority? Number one, it is a grant. The first one is a grant. It is a grant of representation that is going to give you the authority. The grant of representation that is going to give you the authority. So you get the authority from the grant. That is number one. Number two, a will. You get the authority to, entertain the estate of the deceased person from the will. And then number three is a court order. Okay? Or number four, any written law. Those are the four ways you can get authority to entertain or to touch the estate of the deceased person. The first one, a grant of representation. A grant of representation will give you the power and the mandate to entertain the estate of the deceased person or to deal with or interfere with the estate of the deceased person. A grant of representation. A grant of representation. Okay, that is the first one. The second one is the power given by the court. The court can order, the court can issue an order that something in that estate be done. The court can issue an order that you do something. So when you have an order of the court authorizing you to do something in the estate, for instance, sell part of the estate or collect something in the estate or do, transfer some property, all that will be authorized by a court order. That is exactly what I'm saying. So that is the second way in which you're going to get power to deal in the estate of the deceased person. Okay. The second one is through a will. Okay. So when it comes to a will, you know very well that the powers of executors, we have somebody called personal representatives. We'll talk about personal representatives. Personal representatives are people that represent the estate of the deceased person. They could either be administrators or executors. Okay? They could either be administrators or the executors. Now, the executors are appointed by the deceased person. They are appointed in the will. Executors are appointed in the will. Okay? Administrators are appointed after the grant is issued. So as an executor, you are appointed in the will, and you know very well that the powers of an executor will begin from death, not when the grant is obtained. The power of an executor that is named after the will kick off after the death of the deceased person. Why is that the case? Why is that the case? There's a feature in a will, one characteristic of a will that we discussed that reasons or that gives that reasoning that the power of an executor will begin after the death. What is that specific feature? Ipsuge.
A will is ambulatory in nature.
Ambulatorily, sit down. Same way you said ambulatory, you need to ambulatorily sit down. What are you saying? Come back here. What did you just say? That a will is ambulatory in nature. What is the meaning of ambulatory? Ipsuge.
Yes, mwalimu.
What is ambulatory? What is the meaning of ambulatory? Kipsuge Diana, are you there? Can you speak quickly? Time is not on our side. Are you having a trouble with your mic, or you're just being taffeted, not answering questions? Which one is which? Kipsuge Diana, can you hear me? Kipsuge Diana, can you hear me?
Yes, I can, Mwalimu.
Why are you calling me Mwalimu when you're not answering questions? What's wrong with you? I'm speaking to you and you're not answering. You're just sitting there, not saying anything. And you keep calling me Mwalimu. Are you trying me? Can you answer the question? What is ambulatory? When somebody is asking you a question, you answer. What is ambulatory? What is the meaning of ambulatory? You're muted.
Shit. It takes effect after death.
No, that is not ambulatory. That is not ambulatory. Somebody called Mwangi. Are you in the blankets? Can you unmute your video, Mwangi? Why are you sleeping right now? Are you serious with your life? Mute your video. All right. So no, Diana, that is not ambulatory. What is ambulatory? What is ambulatory? Kamiri John, what is ambulatory?
Ambulatory means that a will is capable of moving with the things that are not even there.
Use another term.
It is able to pass the things that will be acquired even at a future date.
Yes, exactly. That is what ambulatory means. A will can dispose of assets that are not yet acquired at the time the will is made. It can take care of future items. It can take care of future items. Are we together? It can take care of. So if you say, for example, if you say that all the shirts that I shall have died owning will go to my brother. At the time you're making the will, you have only 2 shirts. But when you died, you left 20. So the will also dispose all the 20 that you acquired after writing the will. The will is ambulatory. You can structure the will in a way that it takes care of properties that will be acquired at a later date. All the money that I die owning, all my pieces of land. So that means that anything that is a piece of land that is yours, whether you acquired it now or in future, will be made available in the will. That is the meaning of ambulatory. Are we together? Now, let us talk about the point that I'm asking you. And the point is the powers of the executor that is named in the will shall begin at death. As the power of as an executor, your powers will commence after death. What is the feature of a will that is relevant to that point? Yes, Willis Opande.
Yeah, I think The reason why because that happens is because when you look at section 2 of the will, it defines a will as a legal declaration by a person of his wishes or intention regarding the disposition of his property after his death. So that's why, and say it's duly made and executed according to the provision. So the execution of the same happens immediately after the death. Yes.
And stop. Acha kizungu mingi. Acha kizungu mingi, my friend. You know all that kizungu umesema, you are yet to give me the point. What is the point? Janina.
Yes, Mwalimu, I believe the feature of that particular instance that you have said is that a will only takes effect upon the death of a testator. So that is when the will now start to be considered after the death or upon the
Yes,
death of the testator.
that is the simplest answer that I'm looking for. A will shall be valid from death. The moment death occurs, then that will is valid, and therefore the person that has been appointed under the will shall also assume his duties. Okay, you shall assume the duties of an executor immediately after death. Okay, because your powers are derived from the will. Guys, the powers of the executor are derived from the will. However, the powers of the administrator are derived from the grant. You as an administrator, you don't have any power after death. You'll have to go to court, petition the court, so that the court can appoint you the administrator. So until the grant has been given to you, you cannot do anything because your powers will come from the grant. But for an executor, the powers will come from the will. And that is why we are saying the second way in which you can get the power, or you can have the power or the authority to deal in the estate of the deceased person, is through a will. So the first one I've said is a grant of representation. The second one is a will. The third one is a court order. The third one is a court order. And the fourth one could be any provision of a written law. And this could be anything. For instance, if there's a law that says that if somebody dies, then their estate shall be done this way, or the public trustee shall do the following things regarding their estate, then that law will give somebody power to operate in the estate of the deceased person. So without the grant, without the will, without a court order, and without any provision of any written law, thou shalt not touch the estate of the deceased person. And I'm still sticking to those that are coming from those sides that I've mentioned. 2 weeks after burial, putting on the suits of the deceased person, shaanza kuvaa masuti zake, suti unavaa, mashati unavaa hapo, maviatu zake, and you don't have a grant giving you those things you're putting on. Okay, like I've said, one day you shall know. So that is intermeddling. So let us look at section 45. Provides that except so far as expressly authorized by this act or any other written law or by grant of representation under this act, no person shall for any purpose take possession or dispose of or otherwise intermeddle with any free property of a deceased person. Okay, a person who contravenes the provisions of this act shall be guilty of an offense and liable to a fine not exceeding 10,000 shillings or to a term of imprisonment not exceeding 1 year or to both such fine and imprisonment. Okay, this was an older provision. Of course, 10,000 is nothing, but you shall go to jail. Of course, you know there is a provision in the Penal Code, that is section 350. All intermeddlers are prosecuted as per section 350 of the Penal Code. It is a criminal offense to intermeddle in the estate of the deceased person. It is a criminal offense to intermeddle in the estate of the deceased person. Okay, so if you intermeddle, of course, you will be liable. If found guilty, you will be liable to a fine or an imprisonment of up to 1 year, or both fine and an imprisonment term. And then number 2, if you are also an intermeddler, then you will be answerable to the rightful executor or administrator to the extent of the assets with which he has intermeddled after deducting any payments made in due course of administration. So what we're saying is this, that if you intermeddle in the estate of the deceased person, once the administrator is appointed or the executor, they will come to your house and they will tell you, my friend, we are now the executors. We have heard that you squandered 5 million from this estate. Bring it back, give it to us. And they can sue you and they can attach your property and sell for purposes of recovering what you have squandered. And if you are a beneficiary to that estate, then what you will be given will be offset against what you squandered. So that if you are supposed to get 1 million and you squandered 1 million, you will not get anything because they will offset whatever you squandered from you intermeddled with against what you're supposed to be getting. So in terms of dealing with intermeddlers, I've said the first thing is a criminal offense under section 45 1B, 1A, and also under section 350 of the Penal Code. Number 2, all intermeddlers will be answerable to the rightful administrators to the extent of the estate that they have intermeddled. Are we together? That is the second, or that is the second thing about intermeddling. The first thing is what intermeddling is, which of course I've defined as dealing in the estate of the deceased person without an authority, and we've seen the 4 sources of that authority. And then the second thing is, now, what is the fate of an intermeddler? The third thing that you need to understand about intermeddling is then how do you deal with intermeddling? How do you deal with intermeddling? How do you deal with intermeddling? So there are various ways in which you can deal with the intermeddling. If an estate is being intermeddled with, there are various ways in which you can deal with it. The first way you can deal with it is, of course, the way that is provided for under section 46, okay? And that is you report the matter to the police. This very ridiculous provision anyway, but it is there since 1981. There's nothing you can do about it. You report the matter to the police or through the administration officer, that is the chief or the sub-chief or the DO, the DC, the administration officer in that specific location, who then shall report to the police and have the person arrested. Okay, so that is the first way. You can report to the police and have the person arrested, so that whatever they have intermeddled can be recovered from their estate. Yes, are we together? That is the first one. The second way in which you can deal with intermeddling in that instance is to apply for an injunction. You apply for an injunction. Now, this injunction is applied for under Rule 63 and Order 40 of the Civil Procedure Rules. So, Rule 63 of the Probate and Administration Rules, okay? That is Rule 63 of the Probate and Administration Rules. Now, Rule 63 allows a party to bring or to apply the civil procedure rules. Now, you need to understand a few things, okay? You need to understand a few things. The first thing you need to understand, is that the civil procedure rules is not automatically applying to probate matters. The law of succession has got its own rules and its own forms, okay? So rarely do we use notice of motions in the law of probate. Rarely do we use notice of motions in the law of probate. Are you together? Rarely do we use that because everything is in the document that I'm projecting. It is called the Probate and Administration Rules. I know some of you have never heard of this one, and they're wondering, which one is this one? Yes, the Probate and Administration Rules. They are the rules that apply to probate. All the forms that you need to fill are in this form, are in this document. All of them, all the procedures you need to follow when going to a succession court are in these rules. Everything. Are you together? Now, the Act, that is the Law of Succession Act, Cap 160, provides for the substantive law. The rules, that is the P&A rules, provides for the procedural law. Are we together? Just like the Land Act and the Land Registration Act. Are we together? So that is what we're saying. The Penal Code and the Civil and the Criminal Procedure Code. Okay, the Civil Procedure Act and the Civil Procedure Rules. Each act with its own subsidiary legislation. Are you together? So this is the probate and administration rule. So the general rule is we shall not apply the civil procedure rules when it comes to the law of succession. But when you go to section 63, let me just scroll down there. Not section, rule 63. Okay, when you go to rule 63, this is the rule 63 I'm talking about. It allows for the application of the civil procedure rules in certain matters. Okay, so save as is in the act or in these rules otherwise provided and subject to any order of the court or a registrar in any particular case for reasons to be recorded, the following provisions of the civil procedure rules, namely order 5, that is on service, order 2, so order 5, rule 2 to 34, order 11, that is the pretrial matters, order 16, 19, affidavits, 26, 40, 45, 50, together with the High Court procedure rules, cap 8, shall apply so far as relevant to the proceedings under this rule. So these are the orders that you are going to be applying in civil procedure, in the law of succession, in certain matters, not all the matters. Okay, order 5, 11, 19, 26, 40, 45, and 50. So that is what we are saying. So order 40 is this one. Okay, you can see order 40 there. So order 40 is the one that provides for temporary injunction. So you can make an application in probate using order 40, which is a notice of motion, and you're supporting affidavit, and you pray for an injunction an injunction against a specific person within the procedures, okay? And that person could be anyone, including the person that is intermeddling. So if the estate of the deceased person, somebody is already intermeddling with it, then you can make an application and have, okay, and have a court issue an order stopping the person from intermeddling. Are you together? So make an application and ask the court for an order restraining person XYZ from intermeddling. Okay, that is what we are saying. And then the third way in which you can stop an element or an instance of intermeddling is through applying for a limited grant. Which grant is this? Which limited grant is this? Someone? Guys. Say it. Guys, are you guys playing?
Ad litem.
What do you mean ad litem?
Grant ad colligenda bona.
Thank you very much. Grant ad colligenda bona defuncti. That is the grant that you can apply for in an instance where somebody is intermeddling. Why do you apply for that grant? Because it allows you to collect and preserve. So it allows you to go. It allows you to go and collect the property that is being intermeddled with and preserve it. Okay, the collection and preservation. So that specific grant is used in two instances. The first instance is where the property is at the risk of being wasted. It is being wasted because maybe it is perishable, or it will be lost, or the value will be depreciating. And number two, where the property is at the risk of being misused, that is intermeddled. So you can apply for that grant so that the court can give the power to do what? To go and collect and preserve. Okay, those are the three ways in which you can deal with somebody that is intermeddling. The first way is the criminal way, where you report the matter to the police, the person is arrested, and then they are made to repay whatever they have squandered from the estate. Number two, you can apply for an injunction under Rule 63 as well as Order 40 of the Civil Procedure Rules. Are you together? And then lastly, you can always apply for a limited grant at Colligenda Bona, which allows you to collect and preserve the estate. Guys, that is all for intermeddling. Questions? So you just need to understand, you just need to see whether this estate is being intermeddled with. That is all you need to see. Is it being intermeddled with? Is it being is the estate being intermeddled with? That is the only question you need to ask yourself. Okay? If the if the estate is being intermeddled with, what remedies do you have against the intermeddler? There are two things, guys. Is the estate being intermeddled with? How will you know the estate is being intermeddled with? Number one, the person is operating with, disposing or dealing with the property without any authority, without a grant, without a will, without any court order or any provision of a written law. That is intermeddling. Number two, what can you do to stop that intermeddling? Of course, report the matter to the police under Section 46. You can always apply for an injunction under Order 40 of the Civil Procedure Rules, and you can also apply for a limited grant at Colligenda Bona to collect and preserve the estate that is subject to intermeddling. And then lastly is the question of what are the remedies you have against the intermeddler? If the person that is intermeddling, you know the intermeddler, what are the remedies that you have against the intermeddler? The first one are the criminal liability. Okay, number one, we are saying the person is arrested and fined. Remember under Section 45, 1A and B, we said they are fined. Number two, they're jailed. So there's criminal liability. So if they're found guilty of intermeddling, then they can be held criminal liable and they will be sent to jail or they should be fined. And I've said also under Section 350 of the Penal Code. Number two, the intermeddler will be personally liable or answerable to the rightful administrators or the executor. So they'll have to refund, they have to reimburse whatever they have squandered to the administrator or the executor. So they will personally be made to refund. That is the second remedy. So they have to refund whatever they have squandered. They'll be personally liable to refund the estate that they have squandered, okay, to the personal representative. That is the administrators and the executors. Guys, are we together?
Yes,
All
we
right.
are.
That is all about intermeddling. Any question regarding intermeddling? All right. So as I finish that topic, again, like I said, the Lord has sent me to warn people from Western and Luo Nyanza specifically. This is your warning to stop. Okay. All right. Questions? No question. Let us proceed and talk about the last thing that I want us to talk about, which is now contentious and non-contentious probate. Contentious and non-contentious probate. So what is this thing all about? Contentious and non-contentious probate. That is our next topic. Contentious and non-contentious probate. So contentious simply means it is contended. Non-contentious means it is not contended. Okay? In other words, non-contentious simply means peaceful. Nobody's complaining. Nobody's challenging anything. There's no drama. There's no fighting. It is non-contentious. Okay? And then contentious is very, very litigated. People are fighting. Nobody's agreeing. Everybody's not happy. Okay? So I want to start with the contentious probate and let us look at what is the procedure. What is the procedure of a non-contentious probate? So how the question will not ask you what is the procedure of a non-contentious probate, but the question will tell you to describe, advise John on the process they can follow to get the grant. They have come to your office, their father died, now they are the only two beneficiaries left. Now, what is the process they need to do to get the to get to distribute the property. So you have to advise them from the first step to the last step. That is the procedure of a non-contentious probate. What do they need to do? This will happen, then they do it. That's what I'm asking. So, questions? Someone? Not questions, really, answers. What is, someone describe, take us through the process, walk us through, give us a journey. What happens? Where do you start from? Where do you end? We nyinyi watu ni kupimana sasa, tumeanza. Penina, what is the first thing that happens?
Mwalimu, this is just a trial. When when there's non-contentious probate, by how I've understood it from my reading, I believe when someone comes to the office and they want to get the properties of their deceased father, the first thing they can do is apply to the court for letters of administration ad litem, so that they can have locus standi, and to be proved that they are beneficiaries to the estate of the deceased. And then once that is section 29.
What do you mean they apply for grant ad litem?
I believe grant ad litem is for when you want to represent, when you want to bring a suit on behalf of the deceased as a personal representative of the estate of that deceased person. That is how I understand by grant ad litem.
No,
I
it's
still stand guided.
Okay, no, that is not. Grant ad litem is a limited grant. It is a limited grant. Limited grants are only taken out in limited circumstances. It is a limited grant which can only be taken out in a limited circumstance.
Okay.
Are you together?
Yes, Mwalimu, that is well understood.
All right. So guys, what happens? Your grandfather's died. Now you want to tell your grandmother, Jueni Wakili, how they're supposed to get their property. Okay. Are you together? So somebody tell me, you guys, your wakilis. Tianga.
Okay, I'm not clear about the whole process, but let me try.
Okay.
So I think you petition for grant of letters of administration.
In what instance?
Where if it is if intestacy, intestacy.
So give us the entire thing. What needs to happen?
So you petition for the grant of letters of administration.
In what instance? Hey. In what instance?
In cases of intestacy.
Start over again.
Okay. So in case of intestacy, you petition for grant of letters of administration. In the petition, you should have.
Hey.
Yes.
It is not only in the instance of intestacy that you're going to have grants of letters of administration. You know that.
Yes.
But anyway, because we haven't done, but you guys have done it, so I'm not being nice to you. You guys have done this thing. You've done grants, right? Have you done grants? Have you done grants? You?
Yes. Yes.
Okay. Proceed. Now tell me, which grant do you get in what instance? That is what I wanted to be very clear on.
I think you had asked for if you're for the administration of the estate in case in the event that someone dies and they're intestate. I think that's what I was answering. Unless I'm wrong, I don't know.
So start. I've come to your office. And I'm telling you I want to apply for this grant. What will you tell me? Give me the advice. What do I need to do?
Or I'll tell you to get the death certificate and also a letter from the chief.
Leave alone that. What do I need to do? Fine, I have all those things. What do I need to do?
You choose whoever is going to be the.
What? No.
Okay. What's
Take some water. Abdisalan, you started well. You married.
Yeah, Malim, I think you follow the rule procedures from rule number 7 to number 14. First of all, you ask whether the deceased died tested or intested. If he died tested and he had a valid will, you make an application for a grant of probate.
Okay.
If it is he died intested, you make an application for grant of the written will, grant of administration with written will annexed. If it is an oral, you also make an application for a grant of administration for oral will. So there are 3 types of grants you'll apply for. So after that, you take the necessary documentation, and then not everybody can apply for a grant because there is that priority list.
So assume that it can apply. So you've identified the first thing I wanted to get is you've identified the grant that you want to apply for. What next now? Proceed.
So you take the death certificate. You indicate that in the application you indicate the date of death, the domicility.
No,
if he had
you've already prepared the application. Hey, you've already prepared the application. What are you supposed to do now? They have already written what you want them to write. So what do you want them to do now? What next?
You seek the necessary consent if whoever is applying, if he is in the right priority.
Next person, please.
You submit it to court, and then the
next, because you're not giving me the point. Somebody else. Somebody else, please. You already have the document. You already decided which grant you're going to apply for. What next? Alingo.
You take the documents to court for them to be confirmed, to be given.
So you make an application for grant. You make the application. You've already decided which grant is relevant. Each and every scenario will have a different grant. If there's a will that is appointing the executor, you apply for letters of probate, grant of probate. If there's a will that doesn't appoint the executor, then letters of administration with written will are next. If there's no will, letters of simple administration, that is letters of administration intestate. So you've decided that. The next thing you apply, okay? You apply, of course, attaching the relevant documents. We are not going to discuss the relevant documents now. We're just saying you make an application, of course, by filing the relevant petition accompanied by the relevant documents. So you've applied. What is the next step after applying? You've already said the documents are verified, the verification of the document by the registrar. They've been verified. Next. Tamunyo.
Yeah,
Perhaps you you notify interested parties by
Which interested parties, my friend?
Okay, you publish
Take
notice.
some water.
Okay.
Take
Thanks.
some water. Next person. Guys, let me ask you first. Have you guys done this? Maybe it's the first time. Have you guys done this process in class before? Or is the first time, so that I know how to address this issue? Have you done it? Quickly, that's not a hard question. It's a very simple question. Have you done it?
We did not understand.
That is not the answer to the question. Have you done it? Whether you've understood it or not, the question is, have you done it?
Yes, we have done it.
Which class is that? Class what?
Class C.
Class A. Okay.
C.
C, A or C? Can you decide which class you are from?
C. C.
Why are you saying class A?
I've not said A.
All right. So I'm assuming you guys have done it in all the classes. So it's not a new thing. You guys have done it. So can we move together? So the first thing, you decide on which grant you're going to apply for, and you petition for that grant. You petition for that grant, of course, accompanying or including or attaching the relevant documents. Once you file those documents in the registry, then the documents are verified. Verification. The documents are verified by the registrar, or the person that is in charge of the succession registry. They verify whether you have all the documents with you. Once they're verified, what is the next stage that happens? What is the next thing that happens after verification? What is the next thing that happens after verification? Somebody quickly, guys, we can do this quickly, and then we can let you go and relax for the weekend, or we can stay here. Chepkemoi Patricia.
It goes for gazettement.
Nope. Before that, guys. Yes. Guys, before that, what happens? What happens before it is gazetted? Before you get to the point where you're gazetting the document? Yes, Tianga.
You advertise and then the registrar.
Where? What is the difference between advertising and gazetting? Is that not the same thing? And I've said you don't gazette fast.
Okay, the cause is opened by the registrar.
What is open?
The succession cause.
That it has already been verified and the file has been opened. What next? Kezia, Wahoo.
They are assessed, and you pay the fees that is.
That is what you did when you file something. The fact that you filed it means you've already paid for them. We are past that stage. You've already filed it, means you shall lipa. If there's a filing fees, you shall lipa, umekuwa filed. Now, what next? Ngugi, Naomi. Yes, mkuna mchezo.
I can try. They're given to a judge.
The file is placed before the judge. That is the next step that happens. After the verification process, the file is placed before the judge. The file must be placed before the judge if it is in the High Court, and the file must be placed before the resident magistrate or the magistrate if it is in the magistrate court. That is what happens. The file is placed before the magistrate. That is what happens, guys. The file is placed before the magistrate or before the judge. Why is it placed before the judge? So that the judge can go through the file, and if there's a will, then we propound the will. If there's no will, the judge can give an order to advertise. Remember that the order to advertise will only come from the judge, and it only happens if the judge is convinced that the file is proper, that the will has been propounded, and that there is no will. Because that is either there's a will or there's no will. So if you make a petition for letters of administration where there's no will, the judge must confirm that there's no will. Okay, so propoundment of the will. Propoundment of the will simply means the judge will go through the will and confirm whether the will conforms to the legal requirements for making a valid will. That is the process of propounding a will. Is the will valid? Is it properly attested? Is it properly executed? Does it have all the details and everything else? And then if that is proper, the judge will give an order to advertise, that the will be advertised. Okay, so sorry, not the will, the application be advertised. So you file the application, the requisite documents, verification by the registrar, and then it is placed before a judge for the propoundment of the will, if the will is there, either an oral will or a written will. And then after that, the judge will give an order so that the application be advertised in the Kenya Gazette. Okay, what is the next stage? The next stage after that. Paris?
Okay, after the advertisement, if there is no one who will come after 30 days,
Where?
they will grant.
You guys are funny.
Yes, if there is no objection after 30
Where?
days.
Where? Kamunyu Ndungi, please talk to me.
Grant of letters of administration will be issued.
Hey,
The letter of administration. After,
umekunywa leo, then you guys are crazy.
are we talking
Someone
about
else?
the time then? Or we wait for
You keep saying the wrong things. The
of
more you
90
speak, the
days.
more you say wrong things.
Okay.
Kamunyu Ndungi, the more you talk, the more you say the wrong things. Ngugi
Okay,
Naomi.
good.
You
The
guys are
notice,
crazy.
Gazette notice.
And that is your answer. Nyang'au Skita.
Hearing.
Must be nice. Someone else? Kimaru Isaac.
Temporary grant will be issued.
Same WhatsApp group. Someone else? Guys, are you guys normal? Like really, really normal? Huh? Yes, Kamunyu.
Yes, how about after gazettement, then also in
Let's
local
stop there.
newspaper? Okay.
Let's stop there. Guys, the client is in your office. You've decided which application you're going to make. You've made the application. The application has been verified. It has been placed before the judge. The judge has given an order for it to be advertised. Chepkemoi Purity, what is the next stage?
A 30-day period is normally given for objection to be raised.
Wacha tu hapo. Guys, are you guys normal? Like, hebu jishikeni. Maybe you're aliens. You're from another world. Try and touch yourself whether you're alive right now. Slap yourself. What's happening here? Kamunyu.
Goes to the government publishing publishers. You take the notice to the government publishers.
What notice now? You're not giving me what I'm looking for.
Okay.
Somebody else. It's a very simple thing, guys. Basic, simple thing. What is supposed to happen next? We'll be here. I have time. I have time until still just 7 my time. I have time, so we will be here. Sayana George.
Assist for payment.
To chini. Just have a seat and sip some porridge. Someone else. Hey. Niko nchi ingine walai. Yee. Yes, Abdisalan.
Yeah, I think the judge the court will give a notice that an application for grant has been made, and if anybody has an objection, should
Which
do so
grant
within
has
30
been
days.
made? Can you come again? Come again.
That an application for a grant has been made, an application has been made. And if anybody has any objection,
What
you
is
can
that
do so within the next
stage?
30 days. Yeah.
Fine. What you're
The
saying is
notice
not wrong.
stage.
I'm just asking you, what is the next stage? What is the next stage? What do we call it? Not what happens. What do we call it? What is the next stage?
The notice of application. The notice of the application.
So what is that you're saying, my friend? Tanina. Guys.
Mwalimu atry.
Simple English. Don't try. Give me the answer.
The judge or magistrate will appoint the executor named in the will.
Must be nice. Pande.
Confirmation stage.
We hata toka tu, go take a walk. Enda utembee tu kidogo. Baridi kuchape. Chepkoech Valentine.
The gazettement of the application.
Exactly. A very simple thing. Very, very simple, guys. The judge has given an order for the application to be gazetted. See, you gazette it. The application is gazetted. Gazetted.
But
Okay?
that is what we have been
Gazettement.
saying, Mwalimu.
That is what. Repeat what you said. Who is that?
That's what
Say.
we have been saying.
Who is we? Repeat what you said. Tianga Jennifer, what did you say? Because I know what you said. Say it.
It will be gazetted.
You said that is what you said.
There's someone who said that, then you said
Who?
I don't remember who that was.
I had.
Wow. You're crazy. So I'm telling you guys, what you guys are saying is not the thing. You're telling me notice. Notice to what? The next stage is gazettement of the application. The first stage is you make the application. You don't tell me, get the letter from the chief. No, you make the application. The application is verified. Once it is verified, it is placed before a judge. The judge will give an order for gazettement. It is then gazetted. Okay? So in terms of gazettement, now you can discuss with me the modalities of gazettement. How is it gazetted? Okay? How is it gazetted? But first, it is gazetted. First, it is gazetted. And then after it is gazetted, that is when, during that process, you now tell me what happens during gazettement. So the next stage is gazettement. Now, what happens in the gazettement? That is when you discuss the content of the gazette notice and who gazettes it, which is the government printers. Okay, so that you prepare a notice, you make an application for the gazettement, you go to the government printers, you pay. It is normally 500 shillings. I don't think maybe they increased the the fees. Okay, why somebody saying we thought that was already it's already gazetted. Where was it gazetted? You've been given an order to gazette. The judge has given you an order to gazette. Why are you saying after gazettement? It has not been gazetted. You gazette it first by preparing the notice of gazettement, and you take it to the government printers. That notice is usually prepared by the registry. You pay, and then it is forwarded to the registrar. I mean, to the government printers, and then they will gazette it in the Kenya Gazette for 30 days. Okay, so during the gazettement period, the notice is sent out. Just what Abdisalan said, that every person take notice that an application for a grant of letters of administration or a grant of probate or whichever grant has been made by this person. If there's any person out there that has an objection, they should file their objection within 30 days. They should file their objection within 30 days. So make the application, verification by the registrar, the file is placed before the judge, propoundment of the will if there's a will, an order to gazette, gazettement. In terms of gazettement, how is the gazettement done? a notice of that application is published in the Kenya Gazette for 30 days. By who? By the government printers. Okay, what is the content of the notice? The notice is very simple, that take notice. It's a very small thing. Take notice that Abdisalan Gure has made an application for grants of letters of administration in the estate or in respect of the estate of, let's say, Aloy Alawi, deceased person. If there's any person who has an objection to that application, they should file their objection within 30 days from the date of this notice. Full stop. Okay? Full stop. Guys, are we together? That is the gazettement. That is the gazettement stage. Okay? Now, after gazettement, remember this is non-contentious. Non-contentious. After gazettement, what is the next thing that is supposed to happen? Gazettement is done now. Yes, Kamunyu, what happens next?
So within the 30-day period, if there is any objection,
down.
Okay.
Somebody else, guys. What is happening? You guys, it's Friday. I know it's Friday. You guys are tired. Probably a long week. But you guys are not being serious now. Anthony Waire, what happens after gazettement?
Right, Mwalimu. So the grant of letters of administration is now issued after those 30 days?
Yes, it is issued after 30 days. Remember, I've said, Kamunyu, I've said this is non-contentious. It means nobody is objecting anything. It is non-contentious. There is no contention. So nobody is objecting anything. Okay? So after 30 days, if there's nothing, because there will be nothing, which of course I've said it is non-contentious, then a grant is issued. A temporary grant is issued. A temporary grant of probate, if that is what you applied for, or a temporary grant of letters of administration with written will annex is issued, or a temporary grant for letters of administration intestate is issued, if that is what you applied for. Guys, are we together? Are we together?
Yes, Mwalimu.
Perfect. Nice one. Now, let us proceed. Now it has been issued. What happens next? Next? Yes, Kamunyu.
Yeah, so the spouse must apply for confirmation of grant for
spouse. Kamunyu. Kamunyu Ndung.
We are talking about the grandmother. So the grandmother, therefore.
Where are you coming? Where is the grandmother coming from? Are you sober, my friend?
You gave a scenario where if your grandfather dies, so let's talk about. Okay, let me use the technical term. The administrator who has been given or granted letters of administration is therefore supposed to apply for a confirmation of the grant.
No, my friend, no. No, that is not what happens. Don't think too hard. Utaumia akili. Don't think that deep. Guys, what is the next stage? Before confirmation. Confirmation will happen after 6 months, but before then, what is normally supposed to happen? Nyangaus, Kira?
After the grant has been issued, there's typing and proofreading of the grant.
It has been issued. What are you proofreading again? It has been issued.
Okay, it's taken to the judge for signing.
It has been issued. Umepewa kunayo kwa nyumba yako. Unarudia tena. Yuko nayo, ushapewa. Umeitwa ukaambiwa imetoka ndio hii. Nyang'au, enda nayo nyumbani. Unarudia tena, acha niende nione judge. Yaani kama hii, wacha aenda some niambie kama iko sawa. Utafanya hivyo. What next? Tianga.
Distribution of the estate.
Yes, that is usually what happens. In terms of if there's a will, then that step is skipped. But if there's no will, then the parties must agree on distribution. That is the preparation of the distribution schedule, the schedule of distribution, how they are going to distribute. Remember that there is no will in this instance. If there's administration, there's no will. So we have to agree on distribution. But if there's a will, then we skip that stage. Okay. But if there's no will, then we are going to prepare. Within these 6 months, we have to prepare a schedule of distribution which indicates what each and every person is going to get. Remember the requirement under Section 71 of confirmation. You cannot confirm a grant if you don't tell the court how and what each person is going to be getting. Are you together? So you cannot confirm if you don't have that kind of information. So what happens here is the agreement in terms of confirmation. So in terms of distribution. So that is the preparation of the schedule of distribution, which only happens where there was no will, or where there was an oral will. You prepare the schedule of distribution to show what each person is getting. So you document it. All right. And then after that, Kamunyu, come back now.
Where are we? We are after, the distribution of the estate. Then, when the schedule is ready, then you apply for confirmation of the grant.
Yes. So the next thing is application for confirmation of grant, which happens after 6 months. After 6 months from the date you are given the temporary grant. So when you're given the temporary grant, assuming that you're given temporary grant in January, you have until June to agree on the mode of distribution. And then from June to December, you have 6 months to apply for confirmation. If you don't apply for confirmation within that period of time, the grant will be revoked. That is, the temporary grant will be revoked. So after the agreement in terms of the schedule of distribution, then now the personal representative will proceed and apply for confirmation, whether there is an executor or administrator. They apply for the confirmation of grant, attaching the schedule of distribution. Okay. Next stage is, what is the next stage? Next step. The next step, Kamunyu, quickly.
Okay, now that the court has all the documents, then they will. Can I say it will be tabled on the judge's desk so that they can confirm and they are that they are satisfied that all beneficiaries have been adequately catered for. Roughly. Maybe you can assist.
What have you said?
That court will confirm that the schedule and all the application basically has catered. I'm trying to get the words, but maybe I can get assistance.
You you are going to Nairobi and you still want to go to Thika, uende uone nyanyako Embu, ndio urudi tena uingie Kitengela, ukule kidogo nyama, upitie Ngong Road tena urudi. Can you go straight to Nairobi? Yes, Tianga Jennifer.
The confirmation is typed out and signed by the judge.
Wewe tu ni kama Kamunyu Ndungi. Ngugi Naomi. You've made an application for confirmation of grant. Ngugi?
It's already confirmed, so you distribute the estate.
Same was up. Someone else. Mwenye hajaonja kitu leo. Abdisalam, I know you don't drink.
A hearing is convinced.
Hearing for what again?
The judge and to listen whether there any protest. You know, it could still be non-contentious, but there can be any protest in terms of the distribution itself.
No, there's no contention. This is non-contentious. This is non-contentious. We'll come back to contentious, but this is non-contentious.
Then you just issue a confirmed grant. Sure.
So that is the process that it's called what? What is the next stage after you make an application for confirmation? It is?
Confirmation of grant stage.
Exactly. So that is confirmation of grant. Guys, you make an application for confirmation, the grant is confirmed. So don't go around typed, the court verifies, confirm, everybody is sufficiently provided for. No, the grant is confirmed. Okay, the grant is confirmed. Now, once the grant has been confirmed, what next? The grant has been confirmed. What next? It is confirmed and you've been issued with a certificate of a confirmed grant. What next? Yes, Abdisalan?
So you administrate the estate. You administrate the estate according to the terms of the grant. You administrate the estate.
You administrate the estate, and then after administration, what is the last step?
You account to the court, present the accounts and how you have.
Yes, that is perfect. So you file a report with the court and then you are done. So guys, in the next 1 minute, let us do the summary of the process that we've indicated. Guys, it is important for you to know the process because you'll be advising someone. Don't go meandering with words, just go straight to the point. The first thing is you make an application. You make an application, write that down. You make an application for the relevant grant. Make an application for the relevant grant. So in this stage, if the question was telling you that this person died intestate, then you know you'll be making an application for letters of administration intestate. Okay, make an application for the relevant grant. Number 2, the application is verified. Verification by the registrar. Verification by registrar. Okay. Number 3, the file is placed before the judge. The file is placed before the judge for.
Go slowly.
But we've discussed this for 40 minutes. The third one is the file is placed before the judge. Why do we place the file before the judge? For the propoundment of the will. Propoundment of the will if there's a will. Okay. After that, the judge issues an order. That is the fourth one, order to advertise, an order for gazettement. And then the fifth stage is the gazettement. The gazettement stage. So under the gazettement stage, then the notice of the application is sent to the government printers and it is published in the Kenya Gazette for 30 days. It is published in the Kenya Gazette for 30 days, of course, inviting everybody that has an objection to file their objection. Because it is non-contentious, we assume there's no objection. Now, after that, after the 30 days, the sixth stage, guys, are we together up to the sixth one? Are we together up to the first 5 I've said? Tuko sawa?
No, you're too fast.
Yes.
What do you mean I'm too fast? What is it that you're not understanding? Because we've said this for the last 40 minutes. Tianga Jennifer, what is not clear? Tianga Jennifer.
It's the steps, Malimu, because we kept getting it wrong. So I don't know. The way
what
you're
don't
moving
you know?
is fast.
You're saying you don't know.
The steps, they were a bit jumbled up for me. So the way you're moving, because we were giving them for a long period of time. So I just wanted to get the right sequence.
So where are you now?
After the judge is given the order for gazettement.
What is the next stage? We talked about this. What is the next step?
Gazettement.
Tianga Jennifer, what is the next step? Because you are really, honestly, you're not being serious. What is the next step of an order? The judge has given an order for. Guys, we've said this thing. What's happening?
Okay.
Tianga Jennifer, what is the next step?
Gazettement.
And then after gazettement, what is the next one?
Notice of application.
Abdisalan, mute your microphone.
Sorry.
Tianga Jennifer.
Yes.
What is the next step of a gazettement?
Malimu, I'm a bit confused.
Confused about what?
Nipeleka mbio.
Hey, hujaona mbio wewe. What is the next step? Stop breathing like that. Kaniharibia masikio. What is the next step after gazettement? Guys, I've just explained this thing right now. Hata sijatoka penye nilikuwa nimesimama.
That's what I'm saying, Mwalimu. The sequence, it's a bit
There's no
jumbled.
sequence. Tianga, Jennifer, there's no sequence. I'm asking you after you've gazetted the notice has been gazetted. What is the next thing that happens? We've discussed this. What is the next one?
Okay. After the gazettement, you... Let me think about it, kidogo.
Okay.
My thoughts are not clear, Mwalimu. Please just excuse me.
Okay. Guys, the first one, you make an application for the relevant grant. The next one is the verification. The next one, the file is placed before a judge for the proponement of the will. The fourth one, the judge will order for the gazettement of the application. The fifth one, the application is gazetted. The sixth one is the issuance of the temporary grant. The temporary grant is issued. The seventh one, so once the temporary grant has been issued, the seventh one is now where we talk about the preparation of the schedule of distribution, if it is intestacy. And then the eighth one is an application for confirmation of grant, an application for confirmation of grant, where you attach your schedule of distribution. Are we together there until the point, Tianga?
Yes, Mwalimu.
What is the sixth step? Tianga, Jennifer, unmute your microphone. What is the sixth step? Tianga, unmute your microphone. Don't do that with me.
No, Mwalimu, see, just let it slide.
What is the sixth step?
I'll go over it later.
Jikaze Tianga.
You said we are together up to that point. I've just repeated. You've asked the question, which that is exact place where you are stuck. I've gone back and I've repeated it again up to now. What is the sixth one now?
Can you help me?
Who told you? Who told you that?
Well,
I'll
go over it tomorrow morning. I'll go over it tomorrow in the morning.
Kamunyu, what is the sixth step?
The sixth one is publishing the gazettement.
Wewe pia ni kama ndo Tianga.
So
mtafutane.
No, niko sawa. I can start. I can go up to where we've reached number 9.
Number 8. What is number 8?
The preparation of the confirmation of grant.
Hiyo umesikia wapi?
So before that is issuance of the
the two of you. Anyway, guys, for the last time, the first step is you make an application for confirmation. Sorry, make an application for the relevant grant. That is the first step. Make an application for the relevant grant. Number 1. Number 2, that application is verified. Okay, it is verified by the registrar. Number 3, the file is placed before the judge for proponement of a will, if there's a will. Okay, and then number 4, the judge will order for gazettement, or advertisement, whichever you decide to use. The 5th one is now the actual gazettement, where the notice is sent to them, the government printers, and it is published in the Kenya Gazette for 30 days. The 6th one is now the issuance of the interim grant. That is the 6th one. The 7th one is now the preparation of the schedule of distribution. That is within the 6 months after the issuance of the temporary grant, we prepare the schedule of distribution if it is intestacy. And then the 8th one, we make an application for confirmation. We make an application for confirmation. that is attaching the schedule of distribution. And then the 9th one, the confirmation of grant. Once the judge is convinced that everything is clear, the grant shall be confirmed. Are we together up to that point?
Yes.
Yes.
Yeah, Jennifer,
Yeah,
are we together up
Mwalimu.
to that point?
Yes, Mwalimu, yeah.
What is the 6th one?
Issuing of the temporary grant.
Okay, so that is confirmation of grant. That is the 9th one. And then after the grant has been confirmed, then the distribution of the estate, which is simply the administration of the estate. Every beneficiary will take whatever they're supposed to take. That is administration for the distribution of the estate. That is the 10th step. And then the 11th step is the reporting and accounting. Reporting and accounting simply means that the personal representative of the estate will proceed and report back to court. The personal representative of the estate will go and report back to court and tell the court that, Your Honor, you gave me this estate of 20 million. This is how I've distributed, and this is what has remained. I've distributed, each person has gotten this, this, and this, and this, and this. The account balance yenye imebaki ni this one. That is the process of reporting and accounting, and that closes the process of non-contentious probate. That is it. Generally, that is the process of the whole probate, both contentious and non-contentious. It's only that in certain stages that we've spoke about, some contentious might come up in contentious probate. So we are not saying that we have a different step when it comes to contentious probate. No, we're just saying that within the same procedure that we've given, the 11 of them, there's some contention that might come up when you discuss the question of contention. Guys, are we together? Are we together on the 11? So I'm giving the last chance to anyone that is not having the 11 points well captured out. There's nothing that I will look at it in the, tomorrow morning. I know that lie. I've had it a lot of times in my life. So I know that lie. So don't say I will look at it tomorrow morning. There's nothing like that. So any person that is feeling like there's one point that messed up or something is not making sense for them, put up your hand and I'll go through the process again. 2 seconds. 2. Michael Okile, what is this that is not clear? And Camille John.
I was having a challenge unmuting. It's just the last point that I missed after confirmation of grant.
That is not the last point.
Yes, I missed the last point.
The last point or after confirmation of grant, which one?
The last point after confirmation of grant.
That's not the last point. That is the second last. So do you have the last?
I only have confirmation of grant as my last point on my end.
Okay. What comes before confirmation on your end?
What comes before confirmation of grant is an application for confirmation of grant with a schedule attached. Schedule for the distribution of the property.
All right. I'll pick you from there. Kamiri John, what is your contention?
In the real practice, do we have that last point where you report to the court? And what happens in case you don't report? Because personally, I have never heard of someone who is coming to report back that he is through with the procedure.
Yes, you stay next to committee. Do you stay next to committee?
Of course.
Yes. So you will be a visitor at committee if you keep doing that. So one of the duties of personal representatives is you have to account. You have to give a report back to court showing the account that you've done. Okay. In practice, sometimes it doesn't go smoothly. In practice, it doesn't go smoothly like this one. Rarely do we have uncontentious, but it doesn't go smooth. Sometimes it is very smooth, sometimes it's not. Sometimes you can have estates that are being distributed for over 30 years, over 50 years, parties are still in court, 50 years later. Okay. But you as a personal representative, you have a duty to report back to court. And if you don't do that, that is a breach of your duty, and you shall see fire. Naenda kupikia wafungwa huko kamiti. So yes. So let me pick back Michael. So you said confirmation of grant. So we have application for confirmation of the grant is number 8. Number 9 is the confirmation of grant. Number 10 is administration of the estate. The estate is now being distributed. Wewe chukua hii, chukua hii, chukua hii, chukua hii. And that is according to the grant. And then the last stage is where the personal the personal representative, that is the executor or the administrator, reports back to court. Are we together? Everything okay?
Yes, yes, thank you.
All right, so that is the process, guys. So make sure before you go to bed, understand that process, understand that process, guys. Because if you understand it, you are also going to understand the contentious one. Yes, Tianga, Jennifer?
Just a slight question on point 3, where you place the file before the judge for propoundment of the will. So where it is you place the file and there's no will, what does the judge do?
Confirmation of the application itself, whether the application is everything. The judge also confirms if everything is clear. You know, the judge confirms. You see, the registrar only confirms. The registrar only confirms the documents. Have you brought the application, everything and everything and everything? Now the judge now confirms the actual applications. You are saying that you are the wife. Are you the wife here? Okay. Are you the wife here? You are saying that this person died. Where's the death certificate? Did they really actually die? Is it document a forgery? So the judge goes through the application itself. This person was in the jurisdiction as well. So those aspects of jurisdiction and everything else is also confirmed here. So the judge will confirm if everything is proper. Okay, you've drafted the application. There's a way the application is supposed to be drafted. That will not be done by the registrar. Okay, the judge is the one that will confirm whether the application has been drafted properly. Okay, have you indicated the schedule of the assets, the schedule of liabilities, all the beneficiaries? Have you indicated the last place of death and all that? So that is confirmed by the judge. So if there's no will, that is done. But also where there's a will, we propound the will as well as confirming the application. Have you signed? Has it been dated? All those things will be confirmed by the judge. So if the judge is convinced that this file is proper, then the judge will give an order and write there in the file to advertise, to gazette, so that you proceed in gazette. Are we together?
Yes, thank you.
So the work of the registrar is the verification process, which is just to confirm. Do you have a petition? Tick, I have a petition. But they don't look at the content of the petition. Do you have the affidavit? Yes, we have. Do you have the death certificate? Yes, they just tick. It's just a file. It's just a checklist. If you did a judicial attachment in a registry that does succession things, you could have seen the checklist. Have this? Yes, 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 yes. And then they take the file to the judge. So if the judge might decide to return the file back to the registry if something is not clear, and then the registry will communicate back to the person that made the application that something is missing, so that they can go and correct. Okay, sawa. So that is that. Kamunyu Ndungi.
Yes, thank you. While attending a clinical attachment at Ngong Law Courts, I saw such a process happening in court, and I remember the magistrate. She requested to see everybody, all these beneficiaries who are in the schedule. Is that a requirement? I remember
Yes.
she was naming them. Okay.
It
Maybe you
is normally
Mhm.
it is normal. So in the contentious probate, normally it will require everyone to be there, unless when somebody is not able to be there, they normally write to court, write a letter or send a start of declaration that they don't object to the mode of distribution. So what the court normally do is call everyone so that we can ask them right now, because remember the schedule of distribution will just say Kamunyu Ndungi will take 2 acres, so and so will take 2 acres or 3 acres, 3 acres. But now the court must be sure that indeed it is Kamunyu that agreed to take 2 acres, so that it is not like somebody is trying to force you. So the court will ask you, Kamunyu Ndungi, are you okay with 2 acres? And you say yes. They go to your brother. You. So that is a way. It's just a way of ensuring that that everybody is happy. But it is not a legal requirement that they must be there. Like you have to be there. No. the court normally asks for everyone to appear before the judge. But in the instance where they are not able to come, then they need to file documents with the court confirming that they do not have any objections to or any protest regarding the mode of distribution. Okay?
Okay, thanks.
All right. So guys, that is the process of non-contentious probate. It means things are going smooth. So if you're told to advise someone on the process they will take, there's a question on that. I think I'll retrieve it. There's a question on that in one of the 20 series. I will retrieve it so that you can, if you have it, you can send it to me directly on the specific thing that I've discussed. We'll look at it maybe in the next class. So if somebody was to ask you to advise person XYZ on what they need to do, you just look at the entire from first one to the last one, 11 points, okay? And you get your full 10 marks. Don't go into detail. Don't start saying, go to the chief, wake the chief up, greet the chief, ask the chief how the chief slept, ask the chief if she has taken something small, and then, laugh with the chief, and then ask the chief to write the letter. That is a long process. It doesn't make sense, okay? Don't go there. Just say you make the relevant application for the relevant grant. Now, if the examiner is interested in asking you which documents, you will be told in a separate question that list the documents you will be filing in A above, or in this scenario, which documents will you prefer? So don't start saying, make this document, make this, get a consent. No. That is not relevant here. Just say, make the application for the relevant grant. And then if the examiner is interested in the specific documents, you will get a question asking you to list the documents. Just like in the last exam paper, there was a question like that. In the last one, also there was a question like that where you're being told to list the documents you'll be filing. I think in all the 20 series, when I talk about 20 series, I'm talking about June 2021 up to 2024 March. There's been questions on the documents to file. Are you together? So also there's a question on the procedure. So don't go deep into trying to say, oh, if this person is not happy, they will first call their brother and they will ask their brother, why did you not include me? Oh, no, that is a long thing. You don't have the day for that. You can do that when you go to your house with your wife. You can now have a whole story about that exam paper. But for now, just go straight to the point. That is the process of non-contentious probate. Okay. Now, in terms of contentious probate, we shall be looking at the various instances of contention. Okay, the various instances of contention at each and every stage. And that's why I want to start now. We still have 23 minutes. So I want us to discuss at least two contentions that we are going to have. Okay, two contentions that we are going to have. So normally the contentions will begin the moment you file the application. The moment the application has been filed, that is when the contention will begin. So in this process, let us assume that we've already filed. What are the contentions that will come up? What are the contentions that will come up so that we can discuss the contentious probate? The first one is an application for reasonable provision. That is the first one. The first one is an application for reasonable provision. That is the first one. The second one is an objection. You can have an objection. Somebody can file an application for reasonable allocation. Somebody can file an application for objection. Somebody can file the third one, which is the affidavit of protest. Somebody can also file for revocation of grants. Somebody can also bring applications regarding intermeddling. Somebody can also bring a citation, cross petitions. So all that, guys, all that. All those are instances of contention within the probate process. So the process that we've discussed, the 11 pointers, let them stick in your mind. So these things that I mentioned, like contentious probate, they will be fit within the spaces that you have. So from application all the way to the reporting stage, in between, there are some contentions that will come up. Okay, there's some contentions that will come up. Normally, the first contention that will come up before anything else. Okay, from the process of application to the process of reporting, what is the first contention that will come up before you apply for the grant? Which is the first contention that will come up at the first stage before application? before somebody makes an application for the grant, which contention will come up? Quickly, guys, we can do this quickly. We can discuss just two, and then we can go home. Someone, what is the first contention that will come up even before you make an application for the grant? Huku ni wapi? Yes, Langat Robert.
Is the citation.
Perfect. Very amazing answer there. Citation. That is the first one. Citation is usually the first one. It is usually the first one because it happens before somebody applies. So citation is our first contention. That is our first one. Citation. That is the first one because I want us to move within the process so that you don't lose the track of the procedure I've given. So this one happens before you make an application. Citation. Okay. Now, why is citation coming first? Citation it comes first because normally when somebody is cited, you're forcing them to apply. They have refused to apply. So they have not applied yet. You're forcing them to apply or to get out of the way. Okay? So you cite them. You cite them. Are you together? You cite them. Are you together? So that is citation. That is provided for under Rule 21 of the Probate and Administration Rules. Probate and Administration Rules, citation. So I'm just going to explain it, but we'll have an entire discussion about citations when we get to grants. But what you need to understand is, citation is an instance where a person who is entitled but not in priority, they are entitled to make an application for the grant, but not in priority, can cite the person in priority to either apply for the grant or renounce their right to apply for the grant. Are you together? So, when you look at the priority, let me just talk about the priority a little bit so that you understand. The priority of application for grant is if there's an executor, the executor should apply for the grant. If there's an executor, the executor is supposed to apply for the grant. That is where the will has appointed the executor. If there's no executor, then we have the priority under section 66. The first person is the spouse, the surviving spouse. The first person is the surviving spouse. Okay? The second person are the children. And then the third person are other beneficiaries. And then the fourth person is the public trustee. And then the fifth person is the creditor. So the surviving spouse is the first person in priority. The first person in priority is the surviving spouse. The next person in priority is who? The children of the deceased person. They are the second people in priority. Though the spouse and the children can apply all together, they can be co-administrators. So the spouse, the children, other beneficiaries like the mother, the grandfather, the stepbrothers, the sisters, those are other beneficiaries. They can also come together at the third stage. The fourth stage is the public trustee. The public trustee, the office of the public trustee is an office created under the office of the Attorney General and is a public trustee. Okay, so the public trustee can also apply for the grant at number 4. Okay, at number 4. And then lastly on the list, the fifth one and the last person is the creditor. Okay, the creditor. So it means that where the spouse is there, the children are coming second. Where there's no spouse and there's no child, then other beneficiaries will come in place. Where there's no other beneficiary, then the public trustee will come in place. And then where that is also impossible, the creditor will come in place. Okay, so the creditor cannot apply before the spouse applies. And that therefore means that anyone that is lower in priority can go to court and cite anyone that is above in priority, or any person that is entitled to apply first, to either apply or renounce their right. Okay, or renounce their right. And that is called a citation. you cite, you bring a citation application, which is done in summons. All applications in probate are summons, except applications under order 40, that is injunction, of course, in notice of motion. So all applications in probate are summons, and then all pleadings in probate are petitions, not constitutional petitions, the petitions which are standard forms in the rules, petitions. So all the grants, petitions, all the grants, petitions, all the applications are summons. But you don't have to say that. You just say you make an application for citation in the prescribed form. In the prescribed form. Tuko sawa? Tuko sawa?
Yes, ma'am.
Yes. So that is citation. So anytime somebody has refused to make an application for the grant, you cite them to apply. You cite them to apply. Okay? So let us start with 3. The first 1, 2, and 3. 1 and 2 are not important. So every citation shall be served on the person cited, either personally or by acknowledged registered post, unless the registrar directs some other mode of service, which may include by advertisement. So once you make an application for citation, the person you've cited is called the citee. You is the citoo. The citoo is the person applying. The citoo, OR, is the person applying, and the person they're citing is called the citee. So once you make that application in the prescribed form, the registrar shall notify the citee that they have been cited. Are you together? All right. Except where a will is not in the cito's possession and the registrar certified that it is impractical to require to be filed, every will referred to a citation shall be filed in the registry from which the citation is to be issued, but before the issue takes place. That is also not really relevant when you make an application for citation. Of course, if the will is involved, you have to, of course, attach a copy of the will. Now, 5 is very important. A person who has been cited, that is the citee, may appear within 15 days of service of the citation upon him, inclusive of the day of service, or at any time thereafter if no application has been made by the citoo under Rule 225 and 223, enter appearance either in the principal registry or in the Mombasa registry by filing that form. That is just entering appearance. So any person that has been cited on the citee shall enter appearance within 15 days. Okay, within 15 days. Now, after you enter appearance, then the registrar shall proceed and hear the application. Okay, I don't know whether you should go through this, but okay, let's go through it so that you can get the process. So the first process is make an application in the prescribed form, and then service upon the citee. Service upon the citee, and then the citee will enter appearance also in the prescribed form. Are you together? All right. So let's go to 2 to 4 because I'm only focused on the relevant bits of it. 2 to 4 says that a person cited who is willing to accept or to take a grant may petition the court for a grant on filing an affidavit showing that he has entered an appearance and that he has not been served by the citoo with notice of an application for a grant to himself. So what happens is if you are willing to take the grant, then you proceed and petition for the grant. Because why are you being cited? You're being cited to either do 2 things. Number 1, take the grant, or you renounce your right to take the grant. Are you together?
Yes, Mwalimu.
Perfect. So that is clear. So if you've been cited and you're willing to take out the grant, then there's no way you're wasting time. Just proceed and petition the grant for grant. All right. So if the time limited for appearance has expired and the person cited, the citee has not entered appearance in either of the principal registries, either in Mombasa or Nairobi, the citer may, that is the person that cited, in the case of the citation under sub-rule 1, petition the court if he has not already done so for a grant to himself. So if he has not entered appearance within 15 days now, you as the citer, you will now petition for the grant yourself. Are you together? You will now petition for the grant yourself, and then the court, of course, will proceed and issue you the grant. That is the long and short of the provisions under Rule 22. That is the long and short of it. So again, the summary of it. Okay, the summary of it. Now, the first thing is a citation application is made in the prescribed form. A citation application is made in the prescribed form. Number 2, service upon the citee. The citee is served. Okay. Number 3, the citee is supposed to enter appearance within 15 days. Okay, within 15 days, and then file the response. Normally, they file the response indicating why they haven't applied for the grant. But if they are willing to take out the grant, they don't need to. They just proceed and file for take out the grant. And then the next one is that if they don't enter appearance within the time provided, then the citer shall petition the court to be given the grant in his name. Are we together? And that is the process of citation. So I want you to understand citation, because for citation, you not draft a citation application. You not draft it. That is a sure bet. You'll never draft it, but you will advise somebody who is telling you that person X has refused to apply for the grant. What are your remedies? Your remedies are you petition. Okay, but before you petition, what is the remedy? Citation. And what is citation? You make an application for citation in the prescribed form. The citee is served. The citee enters appearance and either files a response on why they have not applied, or they renounce their right, or they remain silent. So if they don't enter appearance within the time provided, then the citer shall put in a petition for the grant to their name, because the person that is supposed to take out the grant has refused to take out the grant. That is the process of citation. So it happens before, citation happens before grant is confirmed. Sorry, before the grant has been applied for, before the point 1. Before point 1. That is, citation happens before point 1. Are you together? Before point 1. That is, citation will happen before point 1. Guys, tuko sawa? We only have 8 minutes, so I need to complete this thing in the next 3 minutes. Tuko sawa? Any question? All right. So that is that. So the next step, the next stage is we are done with citation now. The application has been made, verification has been done, the file has been placed before the judge has propounded the will, and the judge has ordered for the gazettement, and it has been gazetted. Gazettement has been done. Gazettement has been done in the Kenya Gazette. What is the next contention that can come up after gazettement? What is the next contention that will come up? What is the gazettement during the gazettement period? What is the next contention that can come up? Quickly, guys. Somebody tell me. Oh, Pandey, Willis.
Objection.
Objections. Okay. So objection is our second contention. Objection is our second contention. And in terms of objection, it happens after the application has been gazetted. Within the 30 days within which the application has been gazetted, objections will take place. You will object. So any person interested will object. Now, 2 things to note. These are the 2 things you need to take home. Okay, 2 things you need to take home. The first one is that objections happen after the gazettement or during the period of gazettement, within the 30 days of gazettement. That is the first thing. First, guys. The reason why we went through the entire process is for you to understand the stage, because now this is procedural. Once you understand the stage, then now you need to know at what point of the stage do you fix the contention, the dispute. This application will come at what stage? Citation will come early before the application. Number 2, objections will come during the gazettement. You've made the application, it has been gazetted. Now, during the 30 days of gazettement, you are allowed to file your objections with the court. That is the first thing you need to understand, the period and the time for objection, okay? The second thing you need to take home are the grounds of objection, the grounds of objections. So what can you object? Guys, you can't object to everything. What are the things that you can object to? That is the last thing we are saying, and then we can discuss everything else in the next class. Of course, the process of objecting is, again, make the application in the prescribed form. That is a word that should come to your mind all the time, prescribed form. Don't try to answer this question bare-chested. And by bare-chested, I mean you just mentioning forms anyhowly, you know, from this number, this, from this, and you will cry thoroughly. So don't go there and start mentioning form number this, form number this, because there are so many forms and you will forget. Just say make an application in the prescribed form. Are we together? So don't mention the form. So we have known when to object. Number 2, what are the grounds of objection? What do you think are some of the things that are grounds for objection? What are the things you can object to? Number 1, what are the first ground of objection? And then we can close the class there and we resume in the next class. First ground of objection, please. Opande Willis, please talk for us.
You have been left out. Someone has been left out.
Yeah, we Pia talker too. Go out. Guys, I explained this. Guys, this is what I took my time explaining in the last class and the last class. I explained the story of being left out. And I told you very well, guys, when somebody's left out, what do they do? Guys, when somebody's left out, what do they do? Somebody tell me. When you are left out of the wheel, what do you do? There are 2 things you can do, but which one is the required one? Tianga Jennifer, what do you do when you're left out?
You apply for reasonable provision.
You apply for reasonable provision, okay? You apply for reasonable provision. Under what application? Under what section?
26, I'm not sure, 26, I think.
Yes, section 26. You make an application for reasonable provision under section 26. Thank you very much indeed. And then there's also another instance where you'll make an application for reasonable provision that is under section 35. That is the power of appointment. If you've been left out or if the power of appointment has been exercised in an unfairly way, then you will also make an application for reasonable provision. I hope I'm assuming what I've said is not making sense to you. There are 2 instances that you will make an application for reasonable provision. The first one, you've been left out of the will or on intestacy. Nothing has been given to you, number 1. Number 2, you've been given something that you think is inadequate. So you make an application under section 26. That is where the testator or the intestate has left you out with nothing or something small. Guys, it doesn't have to be nothing. It is either you left out completely or you could be given 10 million and that is inadequate because your siblings have been given 100 million each. Wewe ndo umepewa 10. So you can go to court and say, considering what everybody has been given, what have been given is inadequate. Okay, so you make an application under section 26. Okay, the second instance is where the surviving spouse under section 37 is exercising their power of appointment, and that is provided for under 3.5 and 3.6. That is section 3.5 and section 3.6, not section 3.5 of 3 subsection 5, section 35 and section 36. That provides for the power of appointment of the surviving spouse. So I said in this class that when you are the surviving spouse in terms of intestacy, you will enjoy a life interest. As you are enjoying a life interest with your newly found husband, Uncle Gashoki, then during that life interest, you can exercise your power of appointment. It means you will distribute whatever you are enjoying a life interest on to your children, guys. And this, I said, is a traditional aspiration into the act. It comes from a traditional way where we are saying that we don't fight. You as a child, you don't fight your mother for the wealth of your father. You don't know where those people met. You know, you don't know how they made their wealth. You don't know. Go and get a wife and also work for your own. Okay? So based on that, the law said that the wife or the surviving spouse will enjoy a life interest. It means so long as she's still alive, she will enjoy that estate. Okay? But during that time that she's still alive, she can now exercise a power of appointment by saying, my child, my son, this shamba ni yako. Huyu mwingine sister yangu, or my daughter, your son, I mean, this other property is yours. You and you, this one is yours. That's a power of appointment. It means in intestacy, children do not have say over the estate of their father except through the power of appointment. Okay? Now, if you're not happy with the power of appointment, you run to court and you also apply for reasonable provisions under section 35. Okay, that is all out. The grounds of objection, guys. Time has really gone. Grounds of objection number 1. The grounds of objection number 1. What are you objecting to? Okay, let me give you the notice. Take notice that Akinyi Daisy, has made an application. Akinyi Daisy has made an application for what? For letters of grant of probate in respect of the estate of Juma XYZ. If anyone is complaining, let them file an objection. So from that notice, what are you objecting to? Number 1. Grounds of objections. Yes, Kamunyu.
Maybe challenging the validity of the will.
Yes, validity of the will. If the will is invalid, you object. You object to the will. You say that the will is invalid. The validity of a will is raised through objections. Validity of the will. Opande?
You challenge the validity of the executor if they are the rightful executor.
Yes. You've been told that Akinyi Daisy has applied. You will go to court and say, no, Akinyi Daisy is not supposed to apply. So you are challenging the right of executorship and the right of administratorship. So you are challenging the fitness of or the competence of the administrator, okay, or the executor. You're saying, no, they're not supposed to apply. That is the right of administration and the right to executorship. The third one. Okay, the third one is when you are challenging the existence of a will. You are saying the will is not there. There is no will. If the person has made an application for letters of probate saying that there's a will, you can object by saying there is no will. Okay. The fourth one is that if they make an application saying that they're applying for intestacy, you can object by saying there's a will. Okay. So those are the main grounds for objection. Those are really the main grounds for objection. Number 1, you're challenging the intestacy or the testacy status of the estate. The third one, you are challenging the right of administratorship or executorship. Essentially, you are saying, yeye hafai kupewa, mimi nafaa nipewe. For instance, if you go to the list, the priority, if the public trustee has applied, skipping the spouse can object by saying, no, I'm the one in line, I'm the first one in priority, mimi nafaa nipewe, si yeye. So that is, you're challenging the right to administratorship or executorship. And then, of course, the validity of the will. You're saying the will is not properly signed, properly attested, properly executed. The will is not valid. Those are the grounds of objections. So those are the only grounds. Those are the main grounds of objections. So the question of whether I was left out, I was given nothing, no, that is not part of objection. That is not part of objection. That is not part of objection. That is a part of reasonable provision, and sometimes it can mutate and become a question for revocation. We shall see that. So guys, we have seen citation, we have seen objections. So the procedure for objection is under section 17. You make an application for you make an application in the prescribed form stating the grounds of objection. Okay, and then of course you attach your let me not say so that you can go and look at them. Your application for objections and then the cross petition and answer to petition. Okay, so guys, that is that. So we start from objections in the next class, but read on rule 17 as we go. We are starting the way we are going. We have started grants. This is how we start grants. So we are deep into grants. We'll talk about grants, draft a few, and then we can call it a unit, and we can usher you into the exam, and you go and pass this paper. It's very, very easy. Any questions for me before I join the class? It's very late on a Friday. Some of you are already out. Skira.
In the last class, under reasonable provision, I remember you explained that applying under section 26 is before the grant has been made. There's also the other instances. So you said after the grant has been made. I missed that. If you could kindly.
After the grant is made, after the grant has been confirmed, you can only revoke it. Once the grant has been confirmed, you can only revoke it. So any application you want to play with, whether it is protest, whether it is citation, whether it is reasonable provision, all that, you can only do that before the grant is confirmed. Once the grant has been confirmed, the only remedy available is you revoke the grant. Okay, so all these contentions will come early before. Nelewana?
Yes, thank you.
All right. Guys, the recording has been stopped. Wait, Anthony.
Yes, maybe just a quick one. Under this rule 17, when one makes an objection, do you also still have to attach answer to petition and the cross petition as well at the same time, or just that objection form?
No, you have to attach that, because remember, the main ground you are saying this person is not supposed to apply this grant. The reason for objection is you are objecting to them being given the grant. Guys, you are objecting to them being given the grant. Why are you objecting to them being given the grant? Because the will is invalid, or you're saying they're not the right people, they're not the right people, or you're saying the deceased person died, they're applying for the wrong grant, So if you're saying all that, then it means you're the one who should be given. So you have to ask the court to give it to you. So you have to put in your application. Okay, for the same grant. Are you together?
Yes.
Yes, so you have to put in. So when you go there, remember, first there's a qualification for applying for objection. The qualification is you must be a person entitled to the grant, but you've not applied. It means kama wewe auko kwa list ya wenye wanaweza pewa grant, you cannot object. Only the people that can be given the grant can object, because when you object, you are saying the person should not be given, then you are essentially saying, give it to me. You cannot challenge theirs and you're not asking for it. You only challenge theirs if you're also asking for it. So you're saying, huyu asipewe, ni mimi ndo nipewe. Mbona sipewe, hivi na hivi na hivi. So, that is what you're saying. Tunaelewana?
Yes, asante.
But we'll talk about it more. We'll talk about it more in the next class because of time.
All right.
Okay, guys. So the class is being stopped there. The recording is down. So